It's in cases where you receive the amendments, and then in such cases, the amendment shouldn't bring new. It shouldn't raise new facts, but then you can raise facts that is only related to what you have already pleaded. And then, yeah, so I think that's what I have to say.
Okay, right. Yes. So what was the last point we ended with respect to discussion of amendments?
The policy behind.
Did you look at the 16.5?
Yes.
That is, I would leave at any stage. Yes. We discussed that. Yes. Okay. Amendment with leave. Did you start that one?
Yes.
Oh. Okay. Yeah, so but before we move on to amendment with leave, I want to remind you of something I said. If you look at order 16, you notice that it's just written amendments. It's not written amendment of pleadings. So don't let us make the mistake of thinking that order 16 applies only to amendment of what? Pleadings. No. Yes, amendment of pleadings is included, but there are other non-pleadings documents which are also amenable to amendment. And if you read order 16.5, it doesn't talk only about what? Pleadings, isn't it? If you look at the order 16.5, we are told that subject to order 4, rule 5 and 6, and to the following provision of this rule, the court may at any stage of the proceedings upon application by the plaintiff or any other party grant leave to the plaintiff to amend the plaintiff's writ, or B, any party to amend the party's pleading on such terms to cause or otherwise as may be just and in such manner as it may direct. And there come no other, 16 rule 7, amendment of other documents. It said other what? Document. So witness statements, anything in the proceedings, so long as legitimate basis can be laid. If the court considers to be fair and just, it can be amended. So let's take note of that. And of course, when it comes to trial proceedings, if you look at the Courts Act, I think section 69, section 70, 71, those provisions, it was about the minutes or the transcripts of proceedings. And they are supposed to be the official record of what took place in the court. So when you're a lawyer, you have to be very diligent and be interested in the official record. Don't be so fixated with the things you are going to be saying. What you say is important, but what ends up as the official record under the judge's hand is more important. Because that is what will be taken as what happened in the case, isn't it? So it is a good practice if you're a practitioner. All the time, when you go to court and you finish, immediately request for proceedings for the day. And then you review it to make sure that what is captured is accurate. If there's any problem in terms of inaccuracy, immediately you have to bring it to the attention of the court so that the court will correct the record. Because if you don't do that, the record is fixed, it's binding. But then if there's an error in it, you have to bring it to the attention of the court so that it is what? It is written. So that is very important. So you have to keep that in mind when you are going to become like a practitioner. So the last time when we were discussing amendment, yes.
If you are about to start this, I want to ask a question. I observed that the points I was my intention.
Maybe we can, when we finish today's lectures, if we have what to call the miscellaneous. Miscellaneous are things which are not being discussed today, but maybe it's something of interest to civil procedure. We can discuss it. But in order not for us to lose focus, maybe we clear what we want to discuss today, then we can be taking those questions as well. So write it down. Yeah, so that, yes.
Okay. In instances where you want to report errors on proceedings, you make an oral application which should be formal.
Okay, good. If it is something minor, you can just bring it to the attention of the court. And if your opponent on that side has also noticed it and it's something minor, let's suppose there's something proceedings yesterday, then the court is continuing today, and maybe you realize that instead of writing a particular word in an answer or whatever, there was a mistake. You've brought it to the attention of your colleague on the other side, and he also sees what you're talking about. You can just draw the court's attention, and then the court can just do that. Otherwise, you have to go by motion. You have to go by motion, and then you lay the proper basis. But we also have what we call what is the word? They have a term, instant recording of proceedings. They have a certain term, DT, sorry. No, not the, I'm talking about the gadget, the system. No, if you come to the high courts, the circuit courts, the district courts, some of them have automated. So you see screens or computers. That's where the lawyers sit, and then the judge, and then the secretary, the recorder. So you have to pay attention. Look at the screen. If something is not catching, you have to bring it to the attention of the presiding judge so that it will be straightened. Otherwise, if you don't do that, you cannot be heard later on be complaining that the record is not accurate. It's different. If it was a long hand recording, and then it is type or transcribe, that one, there's a significant room for errors to be made. But where it is quite synchronous or it's happening as proceedings are going on, then you can point out any error. But one thing I've observed is that some lawyers, they don't understand that. They don't even look at the screen. They don't look at the screen. So you have to pay attention. Yeah, so we made the point that apart from amendment without leave, which every party can do at least once before close of board, pleadings. And then once one party has made it, the other party has automatic rights to make consequential amendments in order to respond to whatever amendment that the opponent made. So that one is there. However, we noted that even under those rules of order system, where particularly order system rule 1, 2, and so on, where you can do amendment without leave, if your amended pleading is served on your opponent, and your opponent objects to the amendment, the opponent had how many days to come to court and complain? How many days? Hey, you're not looking at your law. Please look at order system, just 2, 3 pages. How many pages? I mean, how many days? No, 14 days. Order system rule what? Order system rule 4. Within 14 days, after the service on the part of a pleading, amended under rule 3. That is amendment without what? Without leave. So plaintiff amended the statement of a claim without leave, or the defendant amended the statement of defense without leave. It is served on you. You examine it closely and say that no, I think that there's something wrong. If the party had brought an application under 16 rule 5 to obtain leave, the court would not have granted the leave due to X, Y, Z. And for that matter, I want to go to court and challenge and have this amended pleading strike out. If you want to do that, Order 16 Rule 4 says that you have a time limit. You have 14 days within which to do that. If you don't do that, you've lost your right. It means that you agree that the amendment is in order. But of course, you should also not do consequential amendments. Because assuming the plaintiff amended the statement of a claim, serve on you, and you've also done your automatic consequential amendment of the statement of defense because of the amendment of the statement of claim, then you cannot be held to come under the 16 Rule 4 and say that the plaintiff shouldn't have amended, and then the court should strike it out. You will be approbating and what? Reprobating. You cannot eat your cake and have it back. Yes. You need a mic, yes. And there should be one mic at the back.
Hello. It's under amendment without
Leave.
Assuming a statement of defense shreds a statement of claim or it tears the statement of claim apart, can the plaintiff do amendment and change the statement of claim because he doesn't need to come to court fully?
Right.
Can
Good.
he change?
Good. And that is how and when Order 16 Rule 4 comes in. Order 16 Rule 4 is sort of like a gatekeeping rule, or it's a filter. Yes, you have the liberty to do one amendment of your pleading without leave. There's no problem. But you must examine the amendment you're going to do and ask yourself, if I had to go to court under Order 16 Rule 5 to seek leave, to ask the court to grant me leave, is it the type of amendment the court will exercise a favorable discretion and grant leave? You must do that self-introspection. So therefore, if you get to know that this kind of proposed amendment, if you have to go to court to get leave, the court is not going to exercise the discretion in your favor, then don't do it. Because if you do it, your opponent will come under the 16 Rule 4, go to court and ask the court to strike it out. And he is likely to succeed. No, he's likely to succeed. Yes. Yes.
The party is allowed an amendment
Once.
without
Leave.
So after I have shredded the plaintiff's statement of claim.
All right. So
now
I got your point. Yeah. So let's say the plaintiff has served the writ and statement of claim on you. You've done your statement of defense after entering appearance. Then the plaintiff realizes that no, if I look at this line of defense, I need to retreat and then reorganize my claim. Otherwise, my claim is dead on what? Arrival. Is that permissible? That's the question. Good. And this is where Order 16 Rule 5 becomes important. Because under Order 16 Rule 5, that's why we need the leave. Although under Order 16 Rule 1, 2, 3, you don't need the leave. But that notwithstanding, you must use the test in Order 16 Rule 5 to determine the appropriateness of your proposed amendment. Like the example that you give, certainly, it's going to be prejudicial. Because assuming, let's say the running down action, and then negligence, the defendant was able to raise some powerful defense. What are some likely defense? in the running down action, like a negligence. Yes?
It was not published. I think I say it was not published.
It was not published.
We're talking about defamation.
No, if it's defamation, then that one is different. I'm talking about like running down, like the negligence. Yes, what are contributory negligence? Act of God. Anyway, yes. So we can imagine all manner of strong defenses. So let's assume that the defendant has been able to set up one and has done it so well that, to use your favorite expression, that is effectively tearing apart or shredding the claim. Then the plaintiff decides to go and amend. Is that permissible? Is it just? Is it fair? Yes, so it will be disallowed. And that is why it's discretionary. So we cannot actually exhaust the... And I want you to read the case I gave you. And if you read that case, the court were making the point that, yes, a judge has a judicial discretion when it comes to amendments. Now, if you want the exercise of your discretion to withstand scrutiny so that it will not be questioned, it has to be transparent. It has to be accountable. You need to demonstrate. So like the example that you give, it's not enough for the judge just to say that it will not be fair and just. So I cannot exercise my discretion to allow this amendment to stand, or rather strike it out. In any case, if you had come under the System Rule 5, I wasn't going to allow it. That is not enough. You must demonstrate. Why are you saying that it will not be fair? So you must demonstrate from the pleadings, the old pleadings, the proposed one, and then the opponent's pleadings, and any other thing, whether the stage, or sometimes too, if you're doing trial, cross-examination might have gone a certain way, and the cross-examination might have been so powerful that it's actually, to use our friend's language, tearing apart the plaintiff's case. So he decides to amend in order to fill in gaps and holes created by the defendant's cross-examination. If you can demonstrate that that is what he's seeking to do, the amendment will be refused. Except that certain evidence might have also come in, which was not pleaded. And then the particular party may want to amend the pleading to align with the evidence. Once the evidence has come in, isn't it? But then if you don't amend for the amendment to fall in line, you may also get a situation where the judge will say that you made like a departure. You set up a different evidence from your pleaded case, as the case may be. But the bottom line is, we cannot exhaust the instances, the situations in which leave will be granted for amendment. It will be determined on case-by-case basis. So that is what we should keep in mind. And that is why we also noted that under the System Rule 5, it can take place at any stage of the proceedings. Remember that? Good. So it can be pre-trial, before trial, as we have seen. After close of pleadings, before trial, you can, during trial, you can amend. Even sometimes towards the end of the trial, you can amend. Even if you look at the NRC, it's even possible to amend on appeal, as the case may be. But that one, you notice that like the court, which so moved to amend it. If you look at the rules, particularly order 16.7, the court on its own motion can also recommend what amendment or order amendment to be made. I mentioned Proper and Smith, and I mentioned a couple of other cases for you to read. I hope you've done that. Good. And I gave some of the factors or considerations which will guide the exercise of discretion and order 16.5, where a person is seeking leave for amendment. And I made the point that the primary consideration is whether the amendment is necessary to determine the rare controversy. Will it help the court to determine the rare controversy? In other words, if without the amendment, the court will not be able to decide the case effectively, or maybe the judgment will be incomplete. The judgment will be the result of incomplete issue because there are some other issues which could have been dealt with, but amendment was not done. If that is the case, then the amendment will be done. Or if it's going to mean that without amendment, you are going to get the party seeking to do amendment mount a fresh litigation, then the amendment will have to be done so that you can achieve the objective of order 1, sub-rule 1, 2, as it were. You want to avoid multiplicity of proceedings. Achieve judicial economy, we talk about that. And then the third one, that there should be no prejudice to the opponent. And that is a question our friend was asking. Will the amendment cause prejudice to the opponent? In other words, will the opponent be inconvenienced? Sorry, it's not the case that the opponent will be inconvenienced, but more importantly, will the opponent suffer injustice? It's not inconvenience, but what? Injustice. As for the inconvenience, it will definitely happen all the time. Because when amendment is made, you may also have to do consequential amendment, or you may need to do some other things. So there'll be inconvenience. Or sometimes even delay or drag the trial a little bit more. So those are the inconveniences. But those inconveniences have their healing balm, and the healing balm is what? It's cost. Cost will be awarded, yes.
The case has gone back and 31 something. And the other party asked that the record would be said that when the amendments made, it do not necessarily affect how far they come, say that the delays are not coming. So I was in court and I realized that one party was asking for the records to be preserved because the other party has been making amendment which is delayed this. And cost was, even though cost was awarded against them.
Madam, where are you going? You're running away. You come back.
So even though cost was awarded against the party asking for the amendments, the other party was still asking that the record be said. So that when the amendment, the person is the amendment, they will still be able to continue without there being debate. Is that something that usually happens, or records be preserved for past amendments?
Well, you see, when amendment is made, it doesn't mean that you are starting de novo. You're not starting afresh. You continue. So I don't know like the particular context in which that happened. Because if assuming a trial is going on and you do amendments, sometimes when the amendment is made, it may be necessary for either, if the party has not closed its case, you may need to probably call another witness. You may need to bring a motion for leave to get a fresh witness statement for another witness. Or sometimes supplementary witness statement, as the case may be, in the light of the amendment which have been granted. Especially if it is to tender a particular document, which was probably not available at the time that the pleadings were settled by the party. and now they're available, and then it's relevant towards resolution of the controversy. They have to come in. And even if the case has been closed by the party, you will bring a motion to convince the court that the court should allow you to reopen your case, as the case may be. So the permutations are many. We cannot exhaust them. We just have to know the principle, and we'll be able to know how they actually work in various situations. So as we said, the bottom line is, with the opponent suffer injustice, that cannot be compensated by cost of procedural accommodation. So the court, as we noted, will ask, will new evidence be required? The amendment, will it going to require new evidence? Or has evidence been lost? Has the defendant or third position? Or will trial strategy be undermined unfairly, just like our friend? It's going to undermine the opponent's strategy unfairly, that may not be what allowed. And mind you, despite the fact that the rule seeks to achieve fairness, the fact still remains that litigation is a contest, isn't it? It's a contest. Is that? Yes. Then we also talk about the fact that the stage of the proceedings is also important. So therefore, where the amendment you are seeking to do is towards the very later stage of proceedings, the bar is very high, as opposed to at the early stages. For example, pre-trial stage, if you are going to look for leave, the consideration would not be so high. But then if the trial has really made advanced stage and a lot of things have gone on, then the court will have to consider the propriety of the proposed amendment in terms of fairness, not causing any prejudice and so on to the opponent. So the later the amendment, the heavier the burden on the applicant. If I say the later the amendment, the heavier the burden, what I mean is that if the case has traveled very far and you are seeking to do amendment, the court will raise the bar rather than if it's just at the very early stage, as it were. And even after evidence has closed, particularly so you've closed your case and you want to do amendment, it's not impermissible, but it's really stringent. It's possible, but it's very, very strict. Very strict. So let's do this, for example, let's suppose that, just an illustration, you have maybe contentious probates, which also include the contentious letter of administration, and there was a caveat and so on. Then the court said that, okay, let a rate be issued. In the course of the trial, maybe they have discovered evidence that the deceased even made the will. And it's very credible. They've gone through everything. And that information needs to be brought before the court, let's say to form part of the case. So even if you have closed your case, let's say as a plaintiff or defendant, the case may be, you will be able to bring the application and persuade the court that this particular document, which is so relevant to the matters in controversy, was not available by use of all diligence at the time that the case was started. So that way it will be allowed. Otherwise, it's very restricted. We also talk about good faith. Do you remember? We said that the amendment has made in what? In good faith. And there should be no bad faith. There should be no mala fides. So what are there? It should only be bona fides. So the opposite of good faith is what? Bad faith. So bona fides or mala fides, that is bad faith. Good faith, bona fides. So what are the indicators of mala fides? bad faith, maybe deliberate tactical delay. And then the deliberate tactical delay will depend upon the situation. Or ambush strategy. The ambush strategy, let's suppose that what you are seeking to amend is not something that you didn't know or you couldn't have known all this while, but then you've waited till this thing. Then that will be ambush strategy, and or attempt to evade adverse ruling. So let's suppose that your friend has brought up an application. Let's say to have your statement of claim strikeout for not disclosing reasonable cause of what? Action. Or to have your statement of defense strikeout under the 11 rule what? Under 11 rule 18, isn't it? 18A or B or C as the case may be for not disclosing reasonable defense. And as soon as you are set with that, you also rush to put together motion for amendment of that particular one, pleading, to attempt to change the goalpost to address what you think your opponent is contemplating in the application that he or she brought, to have your pleading strikeout for not disclosing reasonable, let's say, defense or reasonable cause of action, as the case may be. So here you are attempting to evade adverse ruling, and that is an indicator of a bad faith, of malafide. So that should be what? Disallowed. But of course, if the amendment is genuinely corrective, maybe sometimes you made like a genuine mistake, and then you are seeking to amend that one, it will be allowed. Or it is based on new information, and new information which is relevant to the controversy, then that will be allowed. I asked you to read the case of Muse and Baako. Did you read it? I think 1977, 1 GLR 147. As for the authorities, there are plenty. When it comes to procedure, because what you do in the court, about 60% of what goes on in the court, they're all procedure. Only the 40% are the substantive law. So as for the authorities, there are many. And that is why we say that it's not knowing the too many authorities which is important. Know the principles, and then know some 2 or 3 authorities to support the principles, as it were. We also talk about the fact that there shouldn't be delay, isn't it? So promptitude. We do talk about limitation under 16 Rule 5 2. That's where we ended. A delay, okay. So 16 Rule 5 2, where an application to call for leave to make the amendment mentioned in some Rule 3, 4, or 5 is made after any relevant period of limitation has expired. The court may nevertheless grant the leave in the circumstances mentioned in that application if it considers it just to do so. So let's suppose that you remember the limitations of actions. You know the periods of limitation, the various types of the causes of action, and so on. Yes. So let's suppose that the amendment that we are seeking to make, if you are going by the straight timelines, the period of limitation has what? Has elapsed. If that is not the only basis of the case, but maybe there are some other things, the court will still allow the amendment. The court will still allow the amendment. It may well be that you have accrued defense. In other words, you have a defense which accrued before the relevant period of limitation was amended. Then, if that is the case, the amendment will not be allowed because that will hurt the defendant. the defendant had an accrued right. In terms of a defense, you could canvass against him. Did you read the Akron and Bulle? 1965, JLR 4 says that. Did you read it? Okay, you read it. Now, if you look at the English civil procedure rules, for example, which is largely similar to what we have, where the amendment, for example, merely seeks to recharacterize the same facts. In other words, the same fact, but we are representing it to bring a certain clarity. That will be allowed. Or you are trying to clarify the legal basis of a particular claim or defense, as the case may be. Or you are trying to correct a description, that will be allowed. What about amendment to substitute or add a part to Order 16 Rule 5.3? Order 16 Rule 5.3. An amendment to correct the name of a party may be allowed under sub-rule 2, notwithstanding that it is alleged that the effect of the amendment will be to substitute a new party if the court is satisfied that the mistake sought to be corrected was a genuine mistake and was not misleading, or such as to cause any reasonable doubt as to the identity of the person intending to sue or intended to be sued. So it is possible to correct a name, even if the effect of the name is to do substitution, provided that it was a genuine mistake and not misleading. So maybe, for example, you have sued SY, it's SY Limited, but you omitted the limited. But everything in the case indicates that it is the SY Limited that you tend to sue. So that way, you can break the application for amendment, and then the court will allow it for you to amend the, let's say, the name to be SY Limited instead of just SY as it were. So, just to sum up, in terms of the discretion which the court will exercise, the basic formula, as it were, could be presented as follows in an analytical sequence. 1, is the amendment necessary to determine the rare controversy? 2, does it arise from substantially the same factual matrix? 3, has the applicant acted promptly? I'm just summarizing the key points for you. 4, is the amendment in good faith, that is bona fide? 5, what prejudice will the opponent suffer? What prejudice will the opponent suffer? 6, can prejudice be cured by cause or adjournment? Can that prejudice be cured by cause, so that if you award cause against the parties to the amend, would the other party be okay? Or if you adjourn it, would it solve the problem? 7, does amendment defeat an accrued limitation defense unfairly? Does it defeat an accrued limitation defense unfairly? Now, if the balance favors justice over technicality, then leave will be granted. I mean, if you look at these factors and you think that, no, reasonably, the justice of the case requires that based upon these parameters, it should be permitted, then it will be granted, rather than just holding on to technicalities. Now, what is the relationship with Order 81? Is there any relationship with the remember Order 81, non-compliance, irregularities? Okay. So, if can Order 16 amendment, for example, can it resurrect an action which is a nullity, which cannot be cured under Order 81? And you are meant to cure that? Yeah, so the point to note is that yes, if mistakes or defects are made in processes and procedures, they are not automatically fatal. Nevertheless, Order 16 is not a tool to resurrect an action which is a nullity. An action which in Order 81 cannot what? Cannot kill. And again, two, it can also not resurrect proceedings against a non-existent persons. Non-existent persons. Or where there's a want of jurisdiction, lack of jurisdiction, you cannot amend to cure that. Amendment can only be made within jurisdiction and not where the court does not have what jurisdiction, as it were. There's a case I'd like you to read, NRC number 2 against Gihok refrigeration. As I mentioned the other day, NRC number 2 against Gihok refrigeration, 2007, 2008, Supreme Court of Ghana Law Report, page 16. Hannah Assi ASSI. Number 2. And I would like, it's a very short, it's not a lengthy job, I'd like you to read it. Yes. Yeah. Oh, does the amendment arise from substantially the same facts? That's what does the factual mention, the same thing, the same facts. And if you talk about misnomer, then I ask you to read. Did I mention the case of Gapuha and Kabori? Have you read it? Has anybody read the Gapuha and then the ETS Kabori Sufu? You haven't looked at it? Now, can you amend capacity to sue or be sued? Can it be amended? Let's look at the 16.52. The 16.52. where an application for leave to make amendment mentioned is made after any, then 3, any relevant period of limitation has expired. The court may nevertheless grant the leave in the circumstances mentioned in the application if it considers to do so. Then there's subgroup 3. An amendment to correct the name of a party may be allowed under subgroup 2, notwithstanding that it's alleged that the effects of the amendment will be to substitute a new party. If the court is satisfied that the mistake sought to be corrected was a genuine mistake and was not misleading or such as to cause any reasonable doubt as to the identity of the person intending to sue or intended to be sued. So we've discussed that and then we've cited some cases. What case did we start? And what other case? I mentioned Yeboa and then yes. Okay, so 1654. An amendment to alter capacity in which a person sues may be allowed under subgroup 2 if the new capacity is one which that party had at the date of the commencement of the proceedings or has since acquired. So those who said that you cannot alter capacity, do still maintain your position. So what this means is that when I ask you to be reading the rules or not reading, I said I should be reading the rules ahead of the class. That was our initial covenant when we started. Yes.
My Lord, please. My Lord, please, when you asked your question, I got the sense that you were asking in terms of, let's say the person didn't have the capacity
At all.
Yes. So that was the basis for my answer.
Okay. So let's suppose that someone sued. You want to, yes. Is it the capacity?
Yes.
Okay.
If the new capacity is one which the party had at the date of commencement of the proceedings or has since
Quite, yes.
Will there be an instance where a party will have a capacity before the commencement of the proceedings?
And it will
But
not
we
reflect
found
it.
is that it will not go under that capacity, but that part of the rule is not so clear.
Oh, right, okay. To start with, amendment presupposes that there's an error, there's a mistake, isn't it? And a mistake is a mistake. Either inexperience on the part of the person drafting the pleadings, so that factually the particular capacity might have existed before the action was started, or maybe either inexperience or rush or whatever. The pleading did not capture that. And it may, and of course, don't forget that we have a change of lawyers. You look at Order 75. This is Order 75, yes. Order 75. Lawyers can be changed. And usually, if a party changes a lawyer, the new lawyer will conduct a strict audit to find out whether he is satisfied with how the previous lawyer conducted the case based upon instructions that you have taken from the client during conferencing. So let's suppose that, and that is one typical instance. In fact, if you look at amendments, I can say that about 80 to 90% of amendments come up when there's a change of a lawyer. It's possible for it to occur by the same lawyer, of course. But in practice, most of them, that when you have like a change of a lawyer, and then based upon maybe like the new understanding of this new lawyer of the case or certain things, and then probably he will say that either the pleading was not properly done or does not reflect accurately the case. So the person will come and do amendment. I'm not saying that you must only have a change of lawyer. No, but I'm just talking about what really will happen. So just like this capacity example, it may well be that the capacity was even there, but the lawyer did not even plead it. Did not even plead it. So let's suppose that if let's say you are using power of attorney, it may well be that the power of attorney has been made, stamped and everything, but that fact was not captured, let's say, as part of the pleadings. So let's say that you meet the client and you see the documents he or she has, and you get to know that, no, why is this not reflected in what? In the pleadings. Then you go to the court and get the leave for the amendment to be made. So that is one possible scenario. But there are others. It may also be that when it comes, let's say, the estate, for example. Let's say estate, maybe the estate is being dissipated. Letter of administration has not yet been taken. You're a beneficiary. You go to court, and now the jurisprudence or the case law will say that if those who are supposed to take the necessary LA or probate are not doing that, and then the estate is being dissipated, and your beneficiary will stand to lose. The court exercise both equitable jurisdiction and the common law, isn't it? Yes, so it will be again consistent to allow the estate to be dissipated without you protected. So let's assume that you came, and then later on, or while the matter is pending, you took steps. We do what they call the Order 66 to have what we call the renunciation of probate. Renunciation of probate simply means that usually when a person has died, we have those who are eligible, those who qualify to apply for probate or to apply for letters of what? Administration. But if they are not taking the requisite step, you can get a formal document called the renunciation of probate to be served on them that, yes, you have the right to take probate or take letter of administration. If you are not interested, renounce it. Give up your right so that in law we know that you don't have that right. And then the court will now appoint whoever will approach the court and show a good one, a good case to be appointed. So let's assume that you did that. And now you have become like a personal representative. And the matter you are in court with has to do with the estate. So it's now that you've acquired the status as a proper personal representative. When you started, you just went as a beneficiary. But the estate is not for you alone. But because those who have the legal rights or the legal capacity to do the needful, they're not doing it. And that is why you just rush. And then in the course of time, you're able to regularize the things. So you can do the amendment for that to actually be done. Now, okay, let's talk about, we talk about amendment of other documents, haven't we? Order 16 reward 7. And I want us to look at that closely. Let's look at it. For the purpose of determining the rare question of controversy between the parties, or of correcting any defects or error in proceedings. And mind you, the things we discussed earlier on, correcting any error in what? In what? In proceedings. The court may, at any stage of the proceedings, either of its own motion or the application of any party, order any document in the proceedings to be amended on such terms as to cause, or otherwise as may be just, and in such manners it may direct. And then 7.2, this rule shall not apply in relation to judgment or order. So it may be that an exhibit which was tendered in the trial has wrongly been labeled, or maybe a page of the document is mutilated or is not clear, it's not legible, it's not readable. But the proper version is available. Either the court on its own or a party can move the court that the court should make an order for that to be what? amended so they have the correct one then, or the proceedings itself, or anything. And that is why I'm saying that this is not limited only to pleadings. Anything in that can be done. But then this does not apply to judgment or order. For judgment or order, we have like the slip rule and order 16 rule 10, which we'll talk about very soon. So the court cannot just on its own or at any party's request amend an order or judgment under order 16 rule 7. No. Because order 16 rule 7.2 is quite explicit that it does not apply to judgment or order. Now, what happens where the court has given you leave to amend and you don't amend? The court has given you leave to amend, and usually what happens in court is that when we give leave, you prescribe timeline. Yes, the application is granted as prayed. The defendant is given 7 days to amend the statement of defense and counterclaim, as the case may be. So let's say that the 7 days elapses and you haven't carried out the amendment. What happens? Yes, you've lost the right to amend. So that is what order 16.8 tells us. Where the court makes an order giving a party leave to amend the writ, pleading or other document, then if that party does not amend the document in accordance with the order before the expiration of the period specified for that purpose in the order, or if no period is so specified, within 14 days after the order is made, the order shall cease to have effect, but without prejudice to the power of the court to extend the period. So 2 things. When the court grants the order or the leave amendments, the court will prescribe the time, whatever time the court deems appropriate. I just mentioned 7 as an example, but the court can give 10, 14, whatever time. Now, where the court is silent, the court does not prescribe the period within which the amendment should be made. Then there's a default time regime. And the default time regime under the 16.8 is how many days? 14 days. Yeah, so where the order granting the amendment is silent on the time, then by default, you have 14 days from the date that the amendment was made. So if after the elapse of the 14 days, you don't do it, then you've lost the right. But you can also go for extension before the time will actually elapse. Now, when there's a particular method for putting amendment into effect, you can't just do it anyhow. And that is why order 16 rule 9 is important, that subject to sub rule 2 and to any direction given under sub rule 3 or 7, any amendment authorized under this order. I have a female judge friend. I shared the call with her. She just died. May so rest in peace. She was so strict about rules of court. And it's like the rules of court were just on her, yes. I mean, very, very, very religious about the rules of court and authority. Everything you are doing, you have to cite authority. Sorry. You have to cite authority. So,
Our condolences.
Yeah, so I just, because of the method, that's why you have the leave, but you have to carry the amendments according to the prescribed method. That is why I mentioned them. So how do you do it? May be effected by making the necessary alteration to the document, by handwriting, and in the case of a writ, causing it to be resealed and filing a copy of it. So sometimes you may have just a slight amendment, in which case you can even do it in writing, and then you initial against it with the date. and it happens, let's say, in the courtroom, for example. Usually, when you are doing amendment, you are supposed to write on it, amended so and so and so. First one to leave, granted by the court on or dated. So you have to indicate the leave. When was it made? It should reflect on the process, so that the process will speak for itself that yes, this process, this amended process is first one to leave, dated or granted on a particular date. So that is important. But then where you are going to make so many things, you cannot just do handwriting. You have to retype the whole thing and then refile it. And that is where 1692 become important. So where the authorized amendments are so numerous or of such nature, or learn that to make written alterations to the document in order to give effect to them will make it difficult or inconvenient to read. A fresh document amended as authorized shall be prepared, and in the case of a reissue. So if it's a writ, it will have to be reissued by the register, as the case may be. But as I said, you must indicate amended writs, first one to leave, dated or granted by the court on so and so date, or amended statement of defense, amended reply, amended defense, first one to leave. That should be reflected on it. So that is important. And this is provided by the rule itself. We're not just making it up. So the 16 rule 9.3 says that a writ, pleading, or other document which has been amended under the order shall be endorsed with a statement that it has been amended, specifying the date on which it was amended, the name of the judge who made the order, authorizing the amendment, and the date of the order, or if no such order was made, the number of the rule of this order under which the amendment was made. So two scenarios. We have the amendment without leave. If you did amendment without leave, so for example, if you were amending the rates under the 16 rule 1 without leave, you have to write on it amended rate, first one to the 16 word 1, so that we know the basis of what? The amendment. On the other hand, if you have to amend the rate with the leave, then you come under the 16 rule 5. If you come to the 16 rule 5, you're not going to write rate amended person under the 16 rule 5. No. Rate amended rate, first one to leave, granted by her ladyship Ellen Vivian Amwa, my friend, of blessed memory, dated so and so. So that should be reflected on it as it were. Or if it's a statement of defense, the same thing. Now there's a reason for insisting that the order should be reflected on the process. Can anybody tell us, it's not in the rule, but we can discern it. Can anybody tell us the policy rationale underlying order 16 rule 9.3, that you should indicate the basis of the amendment, whether person to, let's say, order 16 rule 1 or rule 2 if it's without leave, or if it is with leave, then person to the leave, granted by the particular judge, dated. Why is it necessary? Yes.
Please. Is that because the effect of the amendment will be updated when it was amended?
Yeah, I've asked you a question. And somebody came to Ghana to do a research, I'm told. And then the person got to the airport. And then the person asked the first person that he met that I'm here to do a certain study. But first of all, before I start, why is it that Ghanaians, you like asking question back when you are questioned? Then the person said that, but why are you asking me this? So as soon as, so he said that it's not necessary for the research to be done. Yes.
Okay, my lord, so please, I think it's because the effect of the amendment it will be backdated to when it was made. So if you have, let's say, amendments with leave, and then we check the date that you had it, you will know whether the amendment you did was supposed to be an amendment with leave or whether you did the right thing or not. So that is what I think.
Okay. Okay. Yeah, I mean that's it's fair. Yes. Yes. You couldn't hear her. But you have the mic. The mic is not here. As in the mic is the problem. We have it only in few places. Can you repeat what you said?
So I'm saying.
Let's say I'm correct to come to today's topic.
So I'm saying that with the amendments, when you make an amendment, it will be backdated. So if we check the dates for which you did the amendments, we are supposed to know whether at that particular time you're supposed to make an amendment with leave or without leave. So it will help us know the correct amendment that was supposed to be done during that time.
Okay, okay, that is fair. Yeah, I mean the point is we want to know that adjudication is about transparency. The court is about openness, and you should be able to track everything. So in the court, for example, there's something called the things book. If you go to the registry, everything which goes on, we can track it. So you don't want a situation where somebody just smuggles something in and say that's also part of the what? Proceedings. If you are saying amendment was made, you should be able to verify whether it is true. If it was amendment without leave, we see it. You have indicated person to the system rule 1 or whatever. If it was with leave, you indicate the leave, the name of the judge, the dates in which the leave was granted. We can always go back to the records book and then track it. Every court has what they call like the record book, and that is the official record of the judge. And if you take the record book, you see that a good number of judges don't have good handwriting. Yes, but it's transcribed later on. Now let's take out the last thing, and we move on. The slip rule or the correction of clerical errors. Order 16, rule 10. So if you look at the assistant return, clerical mistakes in judgments or orders or errors arising therein from any accidental slip or omission may at any time be corrected by the court, either on its own motion or notice to the parties, or on application without an appeal. Yeah, so it's possible for example, when I was a practitioner, we had a judgment. When we were writing the entry of judgment, that we realized that the trial judge the judgment was in our favor, but the judge had made a big, not a like mistake as to competence or anything, but the typographical error. But it was good because the money was quite huge. The money was about, if you look at it, it was about like 16 million Ghana cedis. But it shouldn't have been that. And it was supposed to be like 160,000. But then how it was written. So when we got it, we made the sign of cross that we made but then of course, certainly, you'll not be able to enforce it. So we had to go back to the court. And then when the judge saw it, the judge realized that no, this was yes. So that kind of like the error that we are talking about, the slip rule as it were. But that error can be corrected by the court either on its own motion or when the court is prompted by a party. Yes. And you don't need to appeal. Let's say that typographical error or very errors who don't go to changing the issue of liability. As whether the plaintiff, the defendant is liable or not, and so on. That has to be determined. So you're not talking about an error in that. No. You're talking about some other mistakes which actually don't go to the issue as to who won or who did not win the case. We are not talking about that aspect. So for those minor, what they call the clerical errors, you don't need to go on appeal for that to be corrected. It can be corrected by the court. So not too long ago, there was a case. We gave judgment to. I gave a judgment, and the case has gone before a number of judges before coming back to me. Sometimes we transfer from one court to another. So a summary judgment has been given in respect of a part of a claim in the commercial court, and then the judge who did it determined the interest rate regime which should govern it. Then there was another component which had to be tried in the normal trial, the full scale of plenary trial. We did, and they still got the judgment, but then the interest and then the regime was somewhat different or something like that. Then the plaintiff who had won the case came back to court that the court should rectify certain errors, and then the court should appoint some accountants to go and do certain interest computation, so many things. And some matters they had also brought up, which the other judge had not accepted. They now wanted to bring it back in the name of what? Ratification of the judgment that we had given. But that sins against the slip rule. What you are looking for, probably like you have to appeal. Because once a judge has given a judgment, you are functus officio. You cannot do anything about the judgment, except where maybe you are coming under the slip rule. We have some clerical errors. Otherwise, you have to go on appeal. So the slip rule is not opportunity for you to sit in judgment over your own case, as the case may be. So let's keep that in mind. Yes.
So I think the following solution to rectify this, you also indicate that the parties will also draw the attention of
the court. Yes.
And by application.
Yes. By application. The court is a court of record. By application. Yes.
Can be corrected by the court colleague or by an application by any of the parties. So it's even in the statement.
Yep. Oh no, you have to be charitable to him. Okay, so I want to discuss withdrawal and discontinuance. So just get out for a minute and then